State of Tennessee versus Michael E. Odom. State of Tennessee versus Michael E. Odom.
Good morning, Your Honors.
Good morning.
I'd like to reserve 5 minutes at the
5
end.
minutes, okay.
And I may finish early because it's, I'm not sure I'm just not sure how in depth. I don't do this every day. So with respect to the panel, there are two issues that that we brought before this court. The first issue is whether or not the correct jury charge was brought before the jury, and whether or not it appears beyond a reasonable doubt that the error of the trial court in omitting the definition of the essential element of knowingly from the jury instructions on the elder abuse count and count 2, whether that did not in fact affect the outcome of the trial. And the second issue that we'll address is the trial court's lengthy interrogation of the appellant immediately preceding jury deliberations, whether or not that violated Article 6, Section 9, against judicial commentary with respect to matters of fact, which would, if that is the case, would be structural defect requiring reversal.
Let me ask a question about your
Certainly,
first
thank you.
issue with regard to the instruction on knowingly.
Absolutely.
I think your argument is it wasn't, that the instructions defined knowingly, but didn't define them again then in that particular section.
That's true. It's contextual. It's a question about the context. I struggled with this mightily as I worked through it, because the question was the men's required of the defendant, was the men's state of mind required of the defendant to have knowingly committed the crime the same as it would have been for an assault, because of the age requirement within the statute defining the offense of elder abuse. And it was not clear to counsel at the time whether or not that level of mens rea was the same. I attempted to work through the contours of that statute and to do appropriate research on it. It was very new. There was little, if any, case law on it, on the elder abuse statute, and so I just sort of had to navigate those waters to the best that I could.
And that kind of raises my next question.
Okay.
There was no objection at trial on either of the issues. Do you agree with that?
Well, certainly I can't argue with the record. What I can tell you is that I tried that case on the 28th of October. I had been incapacitated since the middle of February that year. That was the very first day I stepped back into the office to work. Certainly, I would that there were objections that would have been raised. I was doing well to stand at the podium that day, and I can't make an apology for that. And that's difficult to say, but the panel needs to know this gentleman, in the interest of justice, I needed to come here today so that we could further, discuss this.
Let me ask you this. Let's just assume for a moment he had only been charged with the adult abuse offense and not the count 1 offense. And the trial court had read or charged the jury from the pattern jury instruction. Wouldn't that instruction have exactly the same definition for knowingly that he provided the court for the assault?
I would not argue with the court on that point.
So if he would have simply said, like, trial judges say all the time, knowingly has been previously defined, and that term has the same meaning here, you wouldn't have had an argument.
I don't believe so, but out of an abundance of caution, I needed to make that argument.
Okay, understand.
And as Judge Ayers has rightfully brought up, and the argument has been made that I didn't raise those objections at trial. I'm really here about issue 2, and there's no denying that the court has the right to ask clarifying questions. The state cited in its brief the Falcon case, which I believe Judge Holloway you were on, that you in fact authored, and my reading of that was that comment in Falcon was relatively brief and passing.
Yeah, but he asked the defendant if the 6-year-old child who testified the day before that was the victim of the sexual battery, he asked the defendant, "Are you telling the jury that girl was lying?" It's basically the comment. Although it was brief, it was significant. And it would have been reversed remanded had the proof not been so overwhelming. In fact, that's one of the reasons I wrote the concurring opinion.
Okay.
So that statement is blatantly prejudicial, maybe not the right terminology, to the defendant.
Understood and respected. The state had brought that up, and I wanted to address that. Here, in this particular case, the court went on at length. It was pointed question. It was pointed questioning. It went on for, I believe, the last 12 pages of the transcript. In retrospect, I should have stood up. That's not material now, but when counsel got the transcript back, which was months later, this is down the road, that's when this jumped out. And you look at that and you go back and you look at the sentencing hearing, and please, I say this with all due respect, it's difficult because I'm asked to make this, and I'm trying to make this argument and still be respectful of someone that I respect who's on the bench and in front of whom I will appear again, and highly respect. But if you go and look at the sentencing hearing, which was sort of an emotionally charged moment for the defendant, and as counsel, I was there, and and I want to turn to this, and there are two statements that were made at page 99, at lines 10 through 17. The court says, "The testimony you gave of him being able to jump off his lawnmower and run and do all this, I didn't find it credible. As a matter of fact, I found your testimony totally incredible at the jury trial in that." And then again, later on, she said, "I didn't find that very credible for a man of his age, and looking at him physically with that. I didn't find that to be very credible." And that's one of the things I remember questioning you about. And my concern in that moment was that it was a window into the mind of the person speaking at the time the questioning took place. And I cannot stress it enough that I did not say that because the result was not the result desired, but out of an abundance of caution, before writing the decision, I would ask the court if the audio is in the record, listen to the audio. I don't think the transcript does it justice, but it is difficult to catch the tone and the nuance of this. It is not particularly easy to say, but when counsel watches the wind and the attention of the jury panel go away as the bench is speaking, it's difficult to get up after that and finish.
Can you point to specific questions you believe shows the judge's bias?
It was the overall context of those questions, because the state says she was trying to reconnoiter the state says the court was trying to reconnoiter and clarify the position of the parties physically upon the landscape in that moment for the jury. I'm not sure their physical positioning was necessary for the jury to understand.
In a
what the
self-defense
defense
case?
was. Correct. I mean, it was the fact that he made the argument he made. I'm not sure their geographical positioning, other than they were apart. You know, if he was standing 4 feet to the left or 6 feet back, or where he was standing in relation to the lawnmower, he was away from it. And his story was that the victim dismounted and came around, and they came to blows. But there's a great deal of power in tone and in the nuance of the human voice as it's delivered. And when that is the most powerful person in the room, then all of the oxygen gets sucked out of the room if it's delivered a certain way. And
As I understand it, the trial court gave an instruction about when the court asks questions. Is that correct? Is that instruction
correct.
in there? And did that not cure any concern that you would have?
it might have technically cured it. I don't know that it unrang the bell in the minds of the jurors. And I don't believe there's any instrument known to man that can know that. That's really the reason I'm here. I could have left this on briefs, but I felt compelled to come and give, because there's no harm if there's any question. It's what, a half a day trial. There's no harm in looking deep into this and considering giving a remand. I mean, I've really taken that about as far as I can. But I just want to say that I say that with the utmost respect. I really labored over coming here because I'm primarily a civil attorney. I could have walked away from that day. I could have called the court and said I was not physically up to it. But the defendant deserved to have that. And in all truthfulness, he deserves to have due consideration given, regardless of what the outward facts look like. You know, it's really about that. And thank you. And I'll.
All right, because you have your 5-minute rebuttal left if you want it.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the Court. My name is Alan Groves, and I'm here on behalf of the state of Tennessee. The defendant was convicted of assault and elder abuse after attacking his 73-year-old neighbor over a property dispute. As I understand the two issues that have been raised on appeal, the defendant is arguing that the jury instruction on elder abuse was incomplete because it cross-referenced the definition of knowingly provided earlier in the instructions. He's also arguing that the trial court improperly commented on his credibility through its questioning at trial. Both of these issues are waived, and there's no plain error. So with respect to the first issue on the jury instructions, we've argued in our brief that this issue is waived because the defendant did not contemporaneously object or raise the issue in the motion for new trial. Therefore, this court would be limited to plain error review if it were to address the issue at all. The defendant's brief didn't acknowledge a waiver with respect to this issue, and he didn't request plain error review. And we've pointed the court to a couple of decisions in the past where the courts just declined to even engage in a plain error analysis if the defendant fails to request it, because it is the defendant's burden ultimately to persuade the court that each of those 5 plain error factors are indeed present. So that hasn't been done in the briefing. There wasn't a reply brief filed, and I haven't heard a discussion of the plain error factors today. So I think the simplest way the court could resolve this issue is just to deem the issue waived and not conduct a plain error review. If the court were to engage in that analysis, though, there's no breach of a clear and unequivocal rule of law. I haven't seen any published cases cited by the defendant that prohibit cross-references in jury instructions. And to the contrary, we've cited several cases in our brief where this practice has been repeatedly upheld, especially in the context of a lesser included offense, cross-referencing a definition provided earlier in a greater offense. And just generally, we presume that juries follow their instructions. So to the extent that this is a slight deviation from those other cases, the court should presume that when the jury reaches that statement that this definition of knowingly has been previously provided to you, you should presume that the jury understood that instruction and then cross-referenced, which was only a couple of pages back in the written jury instructions. And we've also argued that it's just not necessary to do substantial justice for the court to conduct a plain error analysis, because the defendant has never contested that he acted knowingly, at least with respect to the result of his conduct, because he was making a self-defense argument. So he was acknowledging that he intentionally, in fact, was punching the victim in the face. He just argued that the victim was the first aggressor. So it's not really necessary to even consider, what prejudice this could have had on that aspect of the trial. He does sort of suggest that maybe he didn't act knowingly with respect to the circumstances of the offense, being the victim's age, that he was over 70 years old. But the jury's verdict accredits the victim's testimony that 3 or 4 months earlier, the victim had told the defendant, I'm not going to fight you over this property dispute. I'm 73 years old. I'm just not going to do this. So the jury accredited that testimony through its verdict, and the defendant acknowledged these folks had lived next to each other for over 30 years, and he compared the victim to his elderly grandparents. So I think there's just simply no prejudice here, even to the extent that the cross-reference may have been inappropriate. If there's no questions about that issue, though, I can turn to the trial court's questioning. Here, the parties do agree this issue has been waived, because under Rule 614 of the Rules of Evidence, you have to have a contemporaneous objection to improper questioning by the trial court. Or if you don't want to make that contemporaneous objection, you at least have to raise it to the court's attention at the next available opportunity when the jury has been dismissed. And here, the defendant does engage in the plain error analysis, so I want to walk through a few of these factors. First, we've argued there's no breach of a clear and unequivocal rule of law, because under Rule 614, the trial court is expressly given authority to interrogate witnesses. It simply can't go so far that it would be commenting on matters of fact, such as the defendant's credibility.
When we read the transcript, are we going to find that the trial court remained impartial in the questioning?
What the transcript reflects is that the trial court had several questions for the defendant after both sides had had the opportunity to question him. And I think the defendant acknowledges that a lot of those questions were pretty innocuous, at least at first. The court was asking about the victim's age, the type of mower that the victim was driving, how the victim was able to dismount, and then the defendant's location. And so I think the defendant probably wouldn't quibble with some of the earlier questioning. Now, as it progresses, that's where we kind of disagree about whether those questions were proper or not. But to Judge Wilson's point, I think even towards the latter end of that questioning, when we're getting into the positioning of the parties, that was critically important for a trier of fact to have an accurate understanding to evaluate the defendant's self-defense claim.
Did the trial judge ask those same types of questions to the other party? As I understand it, it was just an altercation between two people. He said kind of thing for the jury to determine credibility. Did the trial judge ask the other party the same types of questions?
The court did interrogate the victim for a few pages of the transcript. Now, to the extent, I I think the court was more confused by the defendant's testimony, just in terms of how articulate he was in explaining what happened. So I don't think the court was asking the exact same questions to both parties, but it did display sort of this stylistic, preference of wanting to ask its own questions after both attorneys had had the opportunity to.
Were they generic, open-ended type questions, or was it more like a cross-examination
For the victim or
for the defendant?
So the defendant argues that some of these questions were leading, suggesting that it was more like a cross-examination. But under Rule 611, we know that leading questions are permissible in certain instances to develop a witness's testimony. And even on direct examination, you're allowed to do that under certain circumstances. And just kind of by the nature of a trial court needing to step in because of some misunderstanding, I can understand why some of those questions might have been leading. But that doesn't necessarily mean the trial court was cross-examining the witness. And I think what's really important here is in Augustino, the case cited in our brief, it's a post-conviction case where this court recognized that the post-conviction court had unusually rigorous questioning of a petitioner. But it emphasized that as long as the questioning by the court is designed to clarify facts and testimony, that it doesn't matter if the witness's answer ultimately bolsters the state's position. And Judge Ayers, I really think that's what happened here. Towards the end of this line of questioning, you do get some kind of pointed questions about how the defendant might have been able to see the victim dismounting from his lawnmower as it's lurching forward, as the defendant's turning around to go back towards his house. But to the extent that the defendant's answers to that question reflected poorly on his position, that's really not the trial court's fault. It's the court's job to act as a gatekeeper to ensure that the trier of fact has all the information it needs. And if you're just asking a witness, is this what you said? And then the witness says, yes, that is what I'm saying, then it can't be that that would be improper. Otherwise, we would have a really perverse incentive structure where a trial court can never ask a clarifying question if it was afraid the witness's answer might reflect poorly on the defendant. That would be kind of weird if that was the case. So I do think the Augustino case is helpful here to the extent that any particular question would raise any concerns for the court. And I didn't address this plain error factor in my brief, but it has come up a little bit today about the tone of the trial court. And I think I heard the defendant mention an audio recording. To my knowledge, Your Honors, and I could be wrong about this, but I do not recall seeing an audio recording in this appellate record. And I was just briefly flipping through the defendant's brief, saying if he had cited to like timestamps or something, and I didn't see that either. As far as I know, there's only a transcript of the trial. And so I do acknowledge that the transcript accurately reflects what the trial court said, but it does not give the court any indication about what tone was struck. And defense counsel was reading back some of those questions in kind of an aggressive tone, but we just don't know what tone the trial court struck here. And I did, just doing a little preparation for this oral argument, I did come across one case where this Article 6, Section 9 claim was raised, and a defendant did provide an audio recording to the court in the appellate record. And the court ultimately denied plain error review nevertheless, but I do think that that's an avenue available to the defendant to accurately reflect what occurred in the trial court. And another point I wanted to make on that factor, and I did briefly mention this in the brief in the statement of the case, but the defendant did not include a transcript of the motion for new trial hearing in this appellate record. And if he had done so, we would have had been able to see if the trial court made any factual findings looking back about its tone. There was a little discussion in the briefs about what the court said at the sentencing hearing, but of course sentencing is not an issue in this case. It's just because the defendant testified at that hearing, this issue kind of came up a little bit, and the court was pretty emphatic that no, I don't know who you people are. I'm not a biased judge. Your trial wasn't a sham. I gave you a fair trial, but it didn't make any specific findings of fact about its tone during that line of questioning. And I think if we had the transcript for the motion for new trial hearing, maybe there would have been additional findings that would have accurately reflected what occurred in the trial. But I think probably most importantly, it's just not necessary to do substantial justice to review this issue for plain error because we have such overwhelming evidence of the defendant's guilt. So this is not a case where questioning by the trial court really tipped the scales on whether the jury was going to believe the victim over the defendant. And that's because we have photographs of the victim's injuries, which your honors will have the opportunity to review. They show extensive bruising and bleeding on the victim, who's a 73-year-old man. And there's also a body camera video in the record where officers are approaching the defendant shortly after this happened, and it doesn't reflect that he sustained severe injuries or really any injuries that I could tell. Although at trial he claimed that he had a pretty severe punch to the face right between the eyes. The video just doesn't reflect that. And to the contrary, it shows him being extremely defensive, kind of cavalier, and just aggressive and hostile towards the officers. And the jury was able to see all of this, which was completely independent from the trial court's questioning and the testimony at trial. And so that's why I cited Judge Holloway's concurring opinion in Falcon, because Judge Holloway, you thought that the statement made in that case was improper, but on plain error review, you decided that you would have still affirmed because there was such overwhelming evidence of the defendant's guilt. And in that case, it was a recorded telephone call that had incriminating statements by the defendant. And so you concluded, as did the panel, that any error would have been harmless because you had such other independent extrinsic proof. So if there are no further questions, I think I've covered all the points that I wanted to address today, and we would respectfully ask this court to affirm the judgments of the trial court.
Thank you, Mr. Groves. Mr. Dixon, you have your rebuttal time.
I'll make this quick. That particular courthouse and that particular court, I'm often there in lower court matters where we do have an audio record. I'm certain that I'm incorrect about that. There would have been no audio. Would that there had been, that you could have heard it. My concern is, as counsel, is that the line of questioning, the court was visibly frustrated with ADA, wanted to take over questioning, took over questioning. You can't see it. You don't have the video. You don't have the audio. Transcript doesn't convey it. And I ought not to be a witness, but that was there. I was there. And I want to impress upon you that if you, I believe I said this in my brief, if you lay down those transcripts and cover those names, you will see no difference in the tone between the prosecutor and the court. If you can read that and cover those names, as you move from then prosecutor Woodall to the court, the tone does not change, and there was, after that questioning, there was to the reckoning of counsel, there was no retrieving the jury upon that. The air completely went out of the room, and it closed. There was no engagement, and I'll leave it at that. It's maybe technically a simple case. I think if you look deeper, it is perhaps not so simple. I just ask you to take that under your advisement and your wisdom, issue whatever order you believe justice requires. And I thank you for your time, and thank you for your patience.
Okay, thank you, Mr.
Thank you.
Groves. All right, thank you, counsel.